33 minutes after the hour, America. Welcome back. I am Hugh Hewitt on this Tuesday, May the 19th, in the year of the plague 2020. I have been following, in between updates of the pandemic, the case of General Michael Flynn. And I have been doing so warily until the last 2 weeks when the Department of Justice stepped forward and said, we need to dismiss this prosecution. I thought, okay, it's over. He's been exonerated. But then Judge Sullivan wouldn't dismiss the case, and I was astounded. I was astonished. And apparently, not just me. 15 attorney generals of the states have stepped forward, filed an amicus brief written by David Yost, the Attorney General of Ohio, and Benjamin Flowers, Ohio's Solicitor General, but joined in by 14 other states, urging Judge Sullivan to dismiss. I am joined now by Attorney General Yost from Ohio. Good morning, AG Yost. It's good to have you. Are you there, General? Up, General Yost?
Here we
there
are.
you are. Yeah, you're on.
Apologize.
That's okay. Tell me what motivated you and these other states to get involved.
You know, this is really an astonishing development. Cases routinely dismissed, and while the criminal rule technically says with leave of court, it's a prosecutorial decision in a case like this, not really a judicial decision.
What the brief says is what the Constitution has put asunder, let no judge join together. I thought that was a felicitous turn of phrase. But of course, it means that the prosecutorial power belongs to the executive and the judicial power to judge the conduct of a trial belongs to the court. What is Judge Sullivan doing?
Well, he, first of all, did not grant the motion. And then he appointed a quote-unquote friend of the court to argue the case against the government's motion to dismiss, which is really remarkable because the prosecution's motion to dismiss was joined by the defendant. And the judge is only allowed to consider the case in controversy before him or her under Article 3. And I think you've talked a little bit about a case just a couple of weeks ago out of the Ninth Circuit where the Supreme Court said, hey, you're to decide the controversy that the litigants bring you. You're not allowed to go off spelunking on some kind of free-form research project outside the cases that the parties bring to you, court, and remanded the case back with instructions to do it right.
Actually, General Yost, in 40 years, I started at law school at Michigan 40 years ago in Ann Arbor. In 40 years, I have never heard of a judge and a Rule 48 motion. I'm not a criminal lawyer. I've been in criminal court exactly once in my life, so I do not know the criminal law, but I took Crim Pro from Jerry Israel at Michigan, and I remember the prosecutorial discretion is absolute. For many, many reasons, it's absolute. I have never heard of a judge attempting. What would he do? Would he order the Department of Justice to bring a prosecution? You can't do that. It's just not actually, I can't imagine what it would look like.
Well, I was a prosecutor for a good part of my career in state court. We have a similar rule there. And, you know, it's an interesting thing because in America, it's the government that has the burden to prove a case beyond a reasonable doubt. So let's say that the judge doesn't want you to dismiss the case after you've decided that you don't have the goods, that it's not a just prosecution. He says the government will bring its first witness. What does the prosecutor do? The prosecutor gets up and says, Your Honor, the people rest.
Yeah.
There's no evidence, so it's got to be a directed verdict of acquittal. So this is a useless act. It's political stagecraft, and it's inappropriate. You know, when a judge engages in that kind of punditry, they are essentially disrobing themselves of the cloak of judicial impartiality and sitting down at the table, the prosecutor's table themselves.
So the speculation is Judge Sullivan really dislikes General Flynn, and he's going to run out the clock and hope that in January, Joe Biden is the president. He appoints a new attorney general, and the new attorney general will resume the prosecution of General Flynn because this is a motion to dismiss with prejudice, meaning it will not be brought again. That is such an extraordinary abuse of so many rights. The speedy trial, the idea of due process. Can he possibly, in your view, persist in this course of conduct? The Judge Sullivan.
Well, I suppose anything's possible. I hope that that is incorrect. And in any event, 6 months is a very long time to continue this. I would expect that there might be someone involved in seeking an extraordinary writ if that were to occur.
Now, I'm wondering, why hasn't DOJ, in your view, brought an interlocutory appeal to take this up to the D.C. Circuit? Because what the judge did, not only in appointing a special prosecutor, which is without precedent, he also opened the window to sort of putting him in the stocks, right? This is the virtual equivalent of putting Michael Flynn in the old stocks that the Puritans used where people could throw things at him. That's what they're doing here. It's unprecedented.
It is, in my view, an inappropriate role for the judge. As far as the DOJ, obviously I can't speak to them, but just speculating one lawyer to another, my guess is that they feel that the interlocutory appeal would be stronger after there's an actual denial of the motion, because right now it hasn't been denied. All he's done is kept it in abeyance and appointed another retired judge to come in and argue against it. So the facts of the case might be a little stronger after the argument is made and the decision is brought.
Okay, so this comes down to on page 8 where the brief says, this trend is disastrous for the judiciary. It erodes public confidence in the court's ability to serve as neutral arbiters in politically sensitive cases. I agree with that. I also think of every person listening, their due process rights. They would never want a judge to do this to them. Never wish on any defendant that which you would not wish on yourself. And I think Judge Sullivan is torturing General Flynn. I think it is absolutely astonishing and incorrigible to continue to allow him to twist in the wind this way. And is that why the AGs rallied?
Well, they rallied because the AGs are the top prosecutors, or the top law officers of their states. And I think all of us share a concern about the increasingly large role that some on the bench are arrogating to themselves. Justice Gorsuch talks about judicial modesty. I think the case we're looking at here is the exact opposite of judicial modesty.
How many cases did you prosecute, Dave Yost, when you were a state prosecutor?
Well, I led the office, so, several thousands.
Did you ever have a judge tell you you could not dismiss a charge that you wanted to dismiss?
Well, I actually did have that happen once. Actually, when I was in municipal court, there was a domestic violence case, but that judge was later disciplined, not for that, but he's no longer a judge. In fact, is no longer a lawyer.
It's just because it is such a confusion of roles, and I want to go back to the practical implications. He can sit on it, but if he refuses to dismiss, if it's other, he just might be involved in tarnishing General Flynn. I mean, it just might be that. It might be the public stocks. But if he doesn't dismiss, every judge in the country is going to start citing Judge Sullivan as precedent for refusing to dismiss cases. And have you ever, when you were a prosecutor, taken a plea that was subsequently withdrawn?
Sure, it happens from time to time.
And what are the reasons for that?
The interest of justice. Sometimes you find out that a witness is recanted, that the investigation underlying the case was flawed, that there's some fact that you didn't know at the time that the plea was entered that makes the outcome unjust. Prosecutors are unusual lawyers. We hear about zealous representation all the time, but a prosecutor doesn't have that duty. The rules of conduct say that prosecutors are ministers of justice. And I once had a horrible case, and I could have proved it, but I got to the point where my key medical witness recanted, and instead of working around it, against a lot of public pressure, I was convinced that the prosecution was unjust, and I dismissed it because the witness had changed her mind.
And
That's what we want prosecutors to do.
so I think the left hates General Flynn and Trump so much they don't understand that people can plead guilty for reasons unrelated to the truthfulness of their thinking that they're guilty. Would you explain that to people?
Well, sure. If you're in a position where you have spent hundreds of thousands of dollars or even more defending yourself, you may be at the end of your individual wealth to pay lawyers. The emotional toll of being pilloried in public, it wears on you, and it's not unusual, particularly in a very high-profile case, for a defendant to say, "Look, I didn't do what you said I would do. I did, but I want give me a deal." And if they can plead to a lesser charge, maybe cut their liability on a sentence, that can happen.
And how often do you think, is it 5% of cases, 10% of cases, do the defendants taking a plea really wish they had the resources to battle because they think they're innocent?
Well, you're asking a prosecutor here.
Right, I know, but that's why it's important. That's why I think this brief is going to be of incredible importance, because it comes from prosecutors.
My feeling is that the vast majority of people who are charged are properly charged. Our system is set up so that a prosecutor has to evaluate their proof, their evidence in such a strict way. Nobody wants to go to court and lose. So it's really a fairly unusual thing, particularly after a plea is in the record, to be able for a prosecutor to come back and say, you know what, this is unjust. But when it does, it's the height of ethical and appropriate administration of justice.
That's what I was getting at. It doesn't happen very often for very good reasons. But when it happens, a judge should not interfere with the administration of justice. And Dave Yost, my hat is off to you and your 14 other states' attorney general for trying to get the attention of Judge Sullivan to what is rapidly becoming a crisis in judicial confidence because of his obviously political intervention here. Dave Yost, thank you. Always good to talk to you.
Good to talk to you.